actually know what happened and how the proceedings were. So, image writers are here to give us to know barrister. We arrive with image writers. And today we learned that Nnamdi Kanu's co-defendant, Benjamin Mazi, Raji Mazi, David Irish, Chidebere, and we are in court today, and the later reports we got, we heard about the court being adjourned and so many other things. And as it is right now, so many Biafrans are still waiting for an update from me to actually know what happened and how the proceedings were. So image writers are here to bring it live to all Biafrans wherever they are trying to read, and I would like you to bring the word. Thank you.
Well, thank you so much, my brother Chiwendo. My brother, you're welcome to go writers. God bless you. Thank you for having me once again on your platform. Today, of course, you are aware that the charge filed against Raji Mazi, Benjamin Mazi, David and the Shidebere was the charge was in pending since 2015. It was 2017. They were jointly charged with the Mazi and before it was separated. So, and they came up today for hearing because they have been separated. So, the Mazi hasn't been discharged. So, their own came up today for hearing. However, before now, we have filed an application with supplementary reduction challenging the division of the court to hear the charge, to control the trial, on the ground that the 3-count charge filed against them contains elements of alleged offences that were allegedly committed outside the division of Federal Court of Nigeria. So, as such, that we have to go back to where the allegations emanated from and where the alleged acts take place from. So, and it's a fundamental issue, also anchored on 11 provisions of the law, like Section 45 of the Federal Court Act, which is very clear on what will happen where a person is being accused of committing an offense in a division of a Federal Court, or probably in a location outside the division of Federal Court sees of the case, sees of the matter. The law says the person was taken back to where the alleged acts emanated from. Are you with me? Yeah. So we don't actually want to go into the merit or otherwise of the allegations, because that should be the second bite we're going to have at the charge when it's eventually transferred. So because the 3-count charge as constituted are not only bogus. 3-count charge as constituted are not only bogus, but empty and frivolous. In fact, as a matter of fact, I don't see a reason why they should be coming to court to defend that bogus charge. But as law-abiding citizen that will come in to ensure that it ends well. The application was taken today on the merits. Adjourned to 5th of September 2022 of 5th of December 2022 for ruling. So we are hopeful because this application is anchored on strong judicial authorities, like this Supreme Court in the case of Suleiman against FRN, which instance very compelling authority that has to do with the issue of criminal division of Federal Court. So in that case, even the trial commences in Federal Court Lagos on alleged act that took place in Kwara State. Then they proceeded to full trial and they were to judgment in Federal Court Lagos. From there, they come appeal eventually to Supreme Court. Supreme Court declared the exercise, the trial that took place in Federal Court and consequently having before the Court of Appeal Lagos State as exercise in futility because they ought to have been tried before Federal Court Kwara Division because of the fact that the alleged acts constituting their legal offenses took place at Akwara State. So, which is very, very compelling on our own case. The issue of receiving information of a broadcast made in London, where all the charge count one was specific that information was received at Enugu and Anambra. Barr Ifeanyi in this case was arrested in Akwa State. The second offense you have been accused of committing is offense of importation of transmitter, which they found at Obolosizo. These are acts within the confines, within the jurisdiction of Fire Court and Anambra. I don't know what she's doing here. She and David we also accused of frivolous offense of making broadcasts from London. Tell me she with Iran, right? And David Swabisi. I know all of that, apart from them when they have been in Russia. Has David Swabisi and Shidebele and the right have they traveled to London before? So tell me how they can make a broadcast from London and it will consider offense in this country. That will tell you how frivolous and childish and empty the child is. We made it without prejudice, we made it otherwise of the child. We are not talking about it now. We're going to get to that bridge across it. What we're talking now, what's our major preoccupation at this point is for the child to be transferred, for the mother to be transferred to Anambra and Oka. Anambra and wherever the child they preferred. So we get to the bridge across that part. So all the three counts standing today against them constitute element and acts. And it took place in Anambra and Enugu. That's all. So what? There's no. I wonder what they're doing in Abuja here. They're very busy coming to Abuja. So if you go there, we have Fire Court there. We have Fire Court in Abuja, in Aka. We have Fire Court in Enugu. We also have Fire Court in Port Harcourt and Akwa Ibom, if the case be. So it was a very robust argument that was taken today and adjourned for ruling. And we're optimistic, believing that the court will find merit on application and grant him. That is to save them the transport of coming to Abuja, the stress, the inconveniences, the security threats they are being exposed to by coming to Abuja. So whenever the matter is coming up, so when they have a confident photo where they go to take the charge to face the trial. So that's all. That's the purport of the essence of the application taken today. And we are hopeful that on 5th of December 2022 that something good will happen. Because we operate within the ambit of law and we have placed our facts and laws before the courts, awaiting the court to do the needful. So thank you so much.
Thank you very much. As we were saying, we heard about the application for transfer of case to the region where allegedly these crimes were committed. And what I would like you to explain to Biafrans, for instance, if this application is granted as it's been fixed to be ruled on the 5th of December 2022, if this application is granted, does it mean that the whole case is going to start afresh again, or they're going to start from where it stopped here in Abuja?
Unfortunately,
because as you said earlier on, this case started ever since 2015. And since then, there have not been anything that is coming
procedurally, when a matter is transferred to a new judge, in this present case, if application is granted as prayed, and consequently or subsequently transferred to either Anambra or Kafara Court to start afresh for trial. The trial will commence in over. I will call it over, starting afresh. So it means that all evidence given so far in the matter will start afresh. But of course, someone has given evidence in the matter sometime in 2017 about. So and to start afresh. So and we have other strategies lined up towards resolving the issue, towards addressing the incompetence of the child itself. We'll not come to that now. So which I may not be able to discuss here. So, but I can assure you that there will be good. There are robust strategies, legal strategies we are going to adopt to ensure that once the charge is taken to another jurisdiction, we address the competence otherwise. Because the child as the constitution today is not disclosing the offense. It will shock you to note.
Okay. We are live again. Sorry, we apologize. Mobile network. We have to consider immediately round up the interview with our immediate barrister, Sir Ifeanyi Ejiofor. So we did ask barrister, please, I asked you earlier on that we can remember some time ago there was a victory bordering on illegal detention and human rights on one of your clients, um, Mazi Bright Chimezie. And we remember you won that case and a certain compensation awarded, might not be correct with the figure, about 5 million thereabout was awarded to him. And ever since then, we want to know if that compensation was paid or the federal government appealed that very judgment. Thank you.
Let me just say this to you. I was advised of trying to explain lay foundation to the about lay foundation towards answering the question before they went on air. So what I actually want to say to the public at this point in time is simple. Before Thursday last week, that was on 27th of October 2022, when Jolon was delivered in the fundamental rights suit I filed on behalf of my late PA Samuel Ozokoro. So challenging the bloody invasion and the genocidal massacre and killing of my PA during the invasion. So the court ruled in our favor and granted all relief sought in the application on the merits, and consequently directed the SSSDG, the Chief Army Staff, the Inspector of Police to identify the culprits, the personnel who were involved in these statutory acts, and consequently prosecute them, sanction them accordingly. The court also awarded the damages, exemplary and general damages of 155 million against the police. So that's in totality for the past 5 years consecutively, I've been able to obtain damages against the police, the federal government, the SSS, in the total sum of 850 million altogether. Now, let me say this to you, because I will ensure that I have strategies I adopt towards recovering that money, and they must pay all of them to the last word. In the case of Bright Chimezie, of course, you know Bright Chimezie was arrested. That was 2007 or 17. Shortly after 17 years. So in 16 in Akwa Ibom. So when I heard about the arrest, I proceeded to Akwa Ibom then. So to file an application for his fundamental right enforcement. And of course, you know the style of these people, these marauders, call them soulless animals. Once they arrest, they will deny the person access to his relatives, legal representatives, and friends. We don't know where they are. It happened to Chidebe Romudi, because I remember then too. I went to Port Harcourt, Iwacha, to search for him. I personally went to CDS office in Port Harcourt. They denied access to him. They denied us knowledge of having him in their custody. So in the case of Bright Chimezie's matter, when I got to Akwa Ibom, nobody gave me information as to what about. That was 2016 precisely. I'm correct about it. So nobody gave me information as to what about. I proceeded to file High Court Akwa Ibom to file application for his fundamental enforcement to ensure that his produced or released. Then I serve on the DSS, have on the police. So it was hard, and it's not cheap. Honorable Justice Jomo Ojukwu deliver judgment in our favor and granted a compensatory damages of 10 million against the SSS and directed them to immediately release Bright Chimezie. Upon the grant of this application and orders issued by the courts directing the SSS to release him and pay damages, I got an information immediately after the judgment was delivered that Chimezie has been transferred to Abuja headquarters of the SS then. So, and when we are at the verge of trying to take further steps, legal steps to ensure it's out, they filed a notice of appeal, which they've abandoned since 2016 to date. We have taken steps to ensure that it's been dismissed. I won't go into that now. So, but what I can assure you that as of today, we have gotten over 800 million against the federal government. That should be a good money. So, and we're going to devise a very legal way of getting that money from them. And that money must be paid to the letter. That I can assure you. We have legal process towards enforcing the payment of judgment debt. So, and it's extant. I may not start discussing it here because it's a matter of common knowledge. But I can assure you, giving 10 million naira wallet to branch Mazi